right here.
Okay.
But it's on another work desk.
It's okay. Just pull it in.
Okay, cool.
Then you should be able to.
Sure.
Oh, sorry.
Okay.
Oh, awesome. You can do a
Okay.
slideshow. It should open up. Okay, got it. Okay, I have all the attendees joining in. Let me also go live on the Facebook group. Okay, so we are live on the Facebook group as well. Pin to feature. Sounds good. I think we can get going. Where is my video? There. Awesome. Hello, everyone. Thank you for joining and thank you for being patient. We are about 2 minutes, 3 minutes late. Just trying to get our logistics set up. We are live streaming on 2 different platforms, the Facebook group and as well as the YouTube. And this webinar is sponsored by Manifest Law. This is the 6th webinar that we are doing in the past 3 months. And today we have Attorney Gabriela with us from Manifest Law. Hi, Gabriela. How are you today?
I'm doing great. Thank you. Thank you for having me.
No problem. So tell me a little bit more about your background.
Sure. So my name is Gabriela Urizar. I'm one of the attorneys here at at Manifest. And I used to work for the largest firm in the world. I have almost a decade of experience specializing in business immigration and student visas and work visas.
Awesome. Fantastic. So today we are here to specifically talk about the green card process. So a lot of the attendees today are either going through the green card process or they are yet to start the process. So we want to break them down. What are the different categories that are available? What is a visa bulletin? What is a final action date? And what is a filing date, or how the retrogression happens, or how the priority date moves, all the basic stuff. And then we'll do some Q&A as we move forward.
Sounds great.
All right,
Let's
sounds
get
good.
started.
Yeah. Take it on.
So I think you touched on all the points that we're going to be discussing today during our agenda. And we're also going to open it for questions if anyone has a question. So what is a green card? A green card is also known as a legal permanent residency to be able to live and work permanently in the United States. It provides long-term stability for working, for traveling, for family planning. You're able to buy assets and to have a better planning for your family long-term. So we have 2 bases. In order to be able to apply for a green card, you have to have a basis for the green card, right? So we have 2 avenues to get there. We have the employment-based category and the family-based category. So what is the employment-based category? So employment-based is for individuals who are getting a sponsor for a work visa or individuals that are self-sponsoring for, let's say, the NIW, the National Interest Waiver, or if they're talented and they're very successful and talented in their field, they're also able to self-sponsor. And this is for individuals with high skills, achievements, and have an education, right? Then we have the family-based green cards, and this is for spouses, parents, and qualifying family members of either legal permanent residents or of U.S. citizens. Like I was discussing, we have 2 main paths to get to the green card, the employment base and the family base. Here we have a map delineating the employment base. So we have EB-1, which is for priority workers, people with extraordinary ability, researchers, multinational executives. This one is fast moving and it has less of a waiting period because the demand is not as high. Then we have the EB-2 category for people with an advanced degree, meaning a master's or a bachelor's plus 5 years of experience, or they can demonstrate that they have exceptional ability. And then if you can demonstrate that the work that you're doing will be of the national interest for the US, and luckily a lot of people who have a degree in STEM are able to successfully make the argument that their work will be of national interest for the US. Then we have the EBT category, which is for professionals and skilled workers. So these category are for people who will be sponsored by an employer, and they will need to go to a process called the PERM or labor certification. We can take a year and a half to up to 2 years, and you have to work with your employer and the Department of Labor to be able to get through this process. Then we have other categories, less common, like the EB-4 for special immigrants, like certain physicians or religious workers, and the EB-5 for investors. So people that are able to invest substantial investment, which is about $100,000 to $1 million, and show that this money is going to create jobs in the US. Okay, so let's talk about family-based green cards more into detail, right? So like I was saying, this is for people who are family members of either US citizens or legal permanent residents. So US citizens usually get the best chance because there is no waiting time for the immediate relatives of US citizens. So for example, if you're a US citizen and you have a spouse, a parent, or a child who's under 21 and hasn't been married, they can just apply right away. There is no waiting time for them. Also, only US citizens can sponsor siblings, even though sponsoring a sibling can take a long time, especially if you're born in a country that has a long waiting time, like let's say Mexico. It is very useful for long-term planning if you apply for a sibling, and let's say your sibling eventually has children. When the sibling is able to get the application, if the children qualify, they can also be included in the application. So I included a chart here that basically portrays the map of the categories, the different categories for the employment, for the family-based applications. And this is important because when you know what category you fall under, and it could be for both, right? For either employment-based or family-based, this will give you like a key so that you can understand every month when the Department of Labor puts out the visa bulletin, if you can go ahead and apply for the green card application. So we have the first category, which like I said, is for unmarried sons and daughters of US citizens. Unmarried sons and daughters of US citizens. Then we have the second category for spouses and children of legal permanent residents. We have the F2B, which is for unmarried children who are above 21 of legal permanent residents. The F3 category, which is for married children of US citizens, and the F4 category, which is for siblings of US citizens.
Okay, got it.
Any questions so far?
So one question I have is on the employment side, and probably we'll pretty much focus on the employment side today, is how does a company or employer decide that we are going to file on EB-2 or EB-3, which is mostly frequently used category? There used to be a time where EB-2 is much faster to get a green card than EB-3. And it came a point where somebody were porting to EB-3 from EB-2 because EB-3 was faster. So could you touch upon how does an employer decide EB-2 or EB-3 or even EB-1?
Yes, of course. And like you said, sometimes it is faster to do EB-3 than EB-2. And EB-2, the requirements are higher. So it totally depends on the demand and the availability of green cards that they have for each category. So for example, in deciding, and we're talking about the PERM, the labor certification process, because under EB-2, you can also self-sponsor if you're able to show that your work if is of national interest for the US. And another requirement is to show to the government why they should waive the PERM process for you, right? So you skip that process. But now let's just focus on PERM. So when an employer is deciding whether to sponsor a candidate or an employee for either EB-2 or EB-3, it all depends on the role. Sometimes employees get confused and they're like, hey, but I have a master's or I have a PhD, how come I cannot be under EB-2? Because EB-2 requires either a master's degree or a bachelor's plus 5 years. It's not about the employee. The employee could have a PhD, a master's, 20 years of experience. It's about what the role requires at minimum, right? So usually, of course, the role tends to align with the qualifications of the employee because that's why they got hired in that position. So that's how an employer goes about determining which one to pick. If the role absolutely requires a master's or bachelor's plus 5, they go with the EB-2 route. If the role could work with less than these requirements, like let's say a bachelor's in 1 year or even less than that, then they pursue the EB-3 category through PERM.
Okay, so generally an employee gets hired and they work with an employer for 2 years, 3 years, any number of time. Then the employee is thinking, okay, could you start my green card process? The employer says, okay, that's fine, we'll start the process. So the person is already in a role. They got hired a few years back. Then when they are looking at, should I file you on EB-2 or EB-3, how does that determination is made after an employee has spent 2-3 years with an employer already?
I think, of course, the employer takes into account the needs of the team.
Okay.
And how critical this employee is. And something else that I want to touch on that I think most people don't know, and I know this because I specialize on PERM for like 6 years, you can also sponsor an employee for a PERM role for a future role. What does this mean? This means that the employer can go and hire a new student right out of college, and they can sponsor them for EB-2 by putting a role in the future. And the student, now employee, can jump into that role in the future. The only thing that they have to keep in mind is that, sure, it is preferable for them to gain the experience that's needed for that offer PERM role at another job, but it is also allowed for them to gain the experience at the sponsoring organization.
Sure.
Are you able to see my slides?
No, I stopped sharing so that we can explain this.
Oh,
Okay.
sorry. As long as the roles where they gain the experience in the same job is at least 51% or more different, which happens all the time because people get promoted and the roles get different. So making that distinction is very important, but they could be sponsored for a future role. And another thing that is important for people to remember that I think makes employers a little bit scared is that when you file for a prevailing wage determination and the Department of Labor tells you, okay, so you want to sponsor this person for this role in the future, given what you're requiring, let's say EB-2, right? A master's or a bachelor's and 5 years, you have to pay this person, let's say $150,000 because that's how much someone with this credential is making. So an employer who is not very well versed in PERM freaks out when they hear that. But they have to remember that they don't have to pay the employee that amount until the employee is ready to jump in and get their green card. As we know, people that are born in India, this could take 8-10 years. So in 8-10 years, if the employer is able to pay the employee $150,000, that's totally fine.
Okay, got it. So in other words, the green card is a future employment, and
Exactly.
and the employer can say, I am going to apply for green card for you for this position, which requires masters for X number of years. And if that requires a salary of, say, $150,000, that person may not be making $150,000 today. After they get their green card, the employer will hire them for that role and pay them $150,000.
By the time they're ready to jump into the green card. Exactly.
Okay, got it. Sounds good. Okay, so let's take a step back, Gabriela, and then could you explain what is a perm labor certification?
Sure. So a perm labor certification is a process that is established by the Department of Labor with USCIS. And it's basically the reasoning behind it is that you cannot take jobs from US workers, right? So if you are saying that you need an engineer that specializes in robotics, you have to test the market. You have to go into the city where you're sponsoring the job. You have to put out ads on websites, on newspapers, and advertise the job that you're going to give your foreign national employee. After that, you open recruitment and you start getting resumes from possible candidates. Then the manager has to review those resumes and only consider the resumes for US workers. So let's say a brilliant candidate applies, but they need a sponsoring because they have an H-1B. You don't have to consider them, only US workers. If after reviewing all of the resumes from US workers, you determine that there is no US workers who are able, willing, and qualified to take this job, then you can file a form with the Department of Labor, explain the situation. Then the Department of Labor approves the labor certification, which is basically a document saying, you're right. There is no US workers that qualify to take this job. So now you have permission to give the green card to a foreign employee. Once you get a labor certification approved, then you can go ahead and apply for the I-140, which has great benefits for people who are on H-1B, and we can talk about it later.
Okay, got it. So how long does this process take? An employee approaches the employer, or the employer starts the green card process. And let's say they start today. When will the perm labor certification will be issued?
2 years from the moment that you start the process of the labor certification. It takes about a year to do the recruitment.
Okay.
And then it takes about a year for the Department of Labor to review and approve the labor certification. But just filing has great benefits for someone who has an H-1B. Just filing, not even getting a response, just filing.
Just the 1 year process to do the interview, recruitment, prepare the application, and file takes about 1 year. And then 1 more year of process. Just the mere fact of filing gives benefits.
Exactly. So for example, if you have someone who's an Indian national and it's on an H-1B, and they're about to max out of the 6 years of the H-1B, if they have at least a year left before they max out, and they file the perm, and the perm has been pending for at least 365 days, they're able to use that pending labor certification and keep filing the H-1B in 1 year increments, even if they max out.
Okay. So if perm is pending for at least 1 year, then they can get H-1B extension for 1 year.
In 1 year increments, 1 year increments, 1 year increments. And then once they get the I-140 approved, then they can get extensions for their H-1B in 3 year increments, even if they maxed out. So that helps them stay here until there is availability for them to go ahead and apply for their green card.
Okay. So let's dive deeper into one more scenario. There is only 9 months left for an individual and perm has been filed. How would an employer typically handle that scenario?
The way that I handle it as an attorney dealing with these cases all the time was to tell the employee, go abroad, take long vacations, work from home abroad in your country, because we have to remember that all the time they spend outside of the US, it can come back to the H-1B. So that can help you buy a few months, and then when you're closer to your H-1B maxing out, you just file another extension asking the government to give back the time that they spend outside of the US.
So let's say out of 6 years that is available, a person spends 4 weeks for a trip for vacation and 1 week going on a cruise, and another 4 weeks going for their wedding, which means even though it's 6 years of H1B, this 4 plus 4, 8 plus 1, 9 weeks can be recaptured to tell, okay, you have 6 years plus another 9 weeks of H1B that you can use.
Exactly. And all trips outside of the country for at least 24 hours also count. So let's say they want to take a quick trip to Canada and be there for 24 hours. That's one day that they can recapture.
Okay, all right. So how can they prove I was out of the country? What kind of documents do they have to keep? Because somebody is not planning who just got their H1B, something like this will be required 6 years from now. So what documentation do they have to keep in order to recapture?
Definitely passports, even if the passports have expired, because when you leave the country, when you come back, the CBP, which is Custom and Border Patrol, they stamp your passport. So if you can check the stamps on your passport, show copies of the stamps to show, hey, I was out of the country. But also, when you come in and out of the country, using the passport, the government gives you an I-94 record. So anyone can just go online, Google I-94 record, and put in the information of the passport that you used to travel in and out. And it gives you a travel history of all the times that you spend outside of the US.
Fantastic. All right. So perm is approved, Gabriela. Next, for EB-2 or EB-3, what's the second step in the process?
Then you have, once the perm is approved, you have 6 months to file for the I-140. If you pass those 6 months, it expires and you have to restart that process from the beginning. That is why it's so important for foreign nationals who are going through this process to be on top of the case. And once they know that their perm application has been approved, their labor certification, push the attorney to file for the I-140. Once you file for the I-140, you have the ability to either file regular, which could take a few months, or pay a little extra to get it expedited through a premium processing. And you can get an approval for an I-140 within 2 to 3 weeks. For people who are born in other countries, sometimes they can even concurrently file the I-140 and the green card application if their priority date is current. And we can talk about how to find your priority date, right? Another tip that people don't know is that if you are, let's say, an Indian national, but you're married with someone from Switzerland, you can request the country of birth of your spouse so that you are not put on this very long waiting time just because you were born in India.
Okay, got it. So the second step is I-140, and approval of I-140 gives the ability to extend H1B in 3-year intervals, and ability for the spouse to get H4 EAD. So that's another benefit that comes from I-140.
Exactly, yes.
Okay, so what is a priority date?
So a priority date is your ticket in line that tells you when you can go ahead and apply for your green card application. The priority date gets established in different ways. Usually, the priority date gets established when people file an I-140, let's say EB-1 category or family base, when they file the basis, right? However, if you go through the perm process, your priority date gets established even sooner when you file the labor certification. When you file the labor certification, that is your priority date, your ticket in line. You keep it with you and you monitor the visa bulletin every month. If the visa bulletin says, we're taking your number, then you can go ahead, file for the green card application, include your whole family, while file for a travel document, and file for a work permit based on that pending green card application.
Got it. Okay. So 2 years for perm, say 2 weeks for premium processing on I-140, which means about 2 years and say 2 months, or 2 years and 1 month. Then we have a priority date that is coming from the date the labor was filed or date I-140 was filed, depending on which category they are filing for. What is this I-485? And how does this fit into the picture?
Sure. So once you know your priority date and you know that you're current or invited to apply for the green card, then the application for the green card includes Form I-485, which is the actual application of the green card, includes the application for a travel document, I-131, and includes the application for a work permit, I-765.
Got it. So when somebody is telling I have to wait for the visa bulletin to become current in order for me to file this I-485,
Mhm.
because I-140 is approved and then they are waiting for 2 years, 3 years, or any number of days. So what does it mean that my visa bulletin or my date has to become current?
So how do you know that it's correct? So every month, the Department of Labor puts out a visa bulletin. So then, and they tell you this month, like for example, December, they said USCIS will be taking priority dates for filing dates because you have two charts. If you go to employment-based applications, you have two charts, dates of filing and final action date, and it gets people very confused. Why is this important? It depends where you are. If you are inside of the US, most of the times USCIS says, hey, we will honor the dates in the dates for filing, which is so much faster and sooner, right? So people, if they look at the chart and let's say they're from second category, right? And they are born in any other country except China, mainland, India, Mexico, or the Philippines. Right now, for the second category, for dates of filing for all the countries, USCIS is allowing people to apply for their green card application if they have a priority date of July 15, 2024, or sooner, or before the date. So let's say I have a priority date of January 1st, 2024, I can go ahead and apply for my green card. However, if you were born in one of these countries that have a big demand, like India or China, then you see how you have to wait longer. You cannot apply, you have to wait until this chart shows your priority date or a date before. And then the final action dates, which is the other chart, basically tells you when a green card is available to be approved. So if you're inside of the US and you file for your adjustment of status or green card, it cannot get approved. You cannot have the physical green card unless your priority date in final action date is correct. Now, if you're abroad, remember, it's not a requirement that you're physically in the US to complete the perm process. I had so many situations where clients didn't have enough time. They maxed out and they had to go abroad. They could wait abroad throughout the whole perm process, throughout the whole I-140. But the only thing is that now they cannot apply for the green card on their dates of filing. They have to wait for their priority date to be current on their final action dates to be able to go make an appointment at the consulate, get their green card stamp, and come into the US.
Okay, so for example, if let's go to the filing date, what advantages somebody gets? For example, India category 2, EB-2, the filing date is December 1, 2013. And for India, category 2 is May 2013. So it's basically May to December, 6 months advance. This was the filing date. What's an advantage somebody is getting with that 6 month extra they're getting with the filing dates?
So the advantage is that if you're in the US, you can apply sooner. And you can also apply for a work permit. So even if you're maxing out, if you are on a pending adjustment of status application, you technically have a status. So you're able to stay in the US, you're able to continue working, and you're able to travel with your advance parole.
So if my priority dates, for example, is say November 30th, December 2013, I'm eligible to apply for I-485 and apply for AP, apply for EAD. which means if I'm still on H-1B and I lose my job
Mhm.
and I have this application pending with USCIS, which means I will not be kicked out of the country. I have a status. Is that correct?
Well, remember that the application, even though it's a green card and you're in that stage, it still is being sponsored for an employer. So for people to be able to continue on the process, they have to find a new employer. And the application of the I-140 has to have been filed at least 180 days. You can then port the I-140, file a new I-140, and keep your priority date. You're always able to keep your priority date. So let's say your priority date was back in 2014. Now it's 2025 and you got fired. You can go to a new employer, tell them, hey, I already have a priority date. I'm familiar with the process. Can you port my I-140? Then they will be able to file a new I-140, but asking to keep that earlier priority date.
Okay, so if somebody's I-140 is approved on January 1st, 2025, and they continue to work for that employer for minimum 6 months, then the priority date will belong to them. Is that what the 180-day rule belong, Gabriela?
Filed, not approved, only filed. Like,
Okay.
yeah, only filed.
So even it's filed, it doesn't matter if it's approved or not.
So if you filed it and 6 months have gone by, even if it's still pending, you can port it.
Okay, so which gives the ability. So somebody has their I-140 approved from 2014, they get fired this month. They can find a new employer, use the portability to keep the same priority date,
Mhm.
but they still have to go through the PERM process.
Exactly, because the perm process is very specific to the location and the employer.
Okay, got it. All right. So let's take some couple of questions. There is a bunch of questions on the chat. Let me find. Can a candidate apply for EB-2 without any employer support on premium processing? How does the process look like?
Sure. So EB-2 houses two different type of applications: the perm and also the national interest waiver. So let's say this person wants to self-sponsor, they can do it by going the route of the national interest waiver. They don't have to, because it's not tied to an employer, it's self-sponsored. They don't have to be tied to the employer. The employer can fire them. They don't have to look for a new employer. The application belongs to them. They can pay for premium processing. They can do whatever they want. Now, if someone is going through EB-2 perm, they're allowed to pay for premium processing, even if it's being sponsored by an employer. They're not allowed to pay for the recruitment process, and they're not allowed to pay for the filing fees of the I-140 and the labor certification. But they're allowed to pay for premium processing.
Okay. So if they do NIW, there is no PERM. They can file directly I-140.
Mhm.
And what's an advantage somebody gets by doing this without skipping PERM?
Owning your petition. You can go anywhere you want. You don't have to rely on another employer. If they fire you, you're fine. It gives a lot of benefit. You also skip the 2 years that it will take for a perm to be approved. So it is faster,
Mhm.
it is more cost effective, and you have a lot more freedom and flexibility in terms of where to move. Remember, perm is tied to the location. So if you move to another location to work in another location, you have to refile the perm.
Okay. So someone listening to this is going to ask, how do I do NIW? How do I qualify for that? Can everyone do it, or it's going to be a certain set of applicants?
So for the NIW, you first have to meet the first criteria. So you either have an advanced degree or you can show that you have exceptional ability. So for someone that has a master's, then you can move towards the next step. And I will explain the next step. But if you don't have a master's, if you only have a bachelor's and 1 year, you can, but you're very good in your field, you have a blog, you go to conferences, and this is another benefit of the NIW, that it gives foreign nationals agency, right? It gives them their power back. If I'm a student, I don't want to be relying only on the H-1B lottery, which is lottery-based, or an employer. But if I really want to stay in the US, there are things that I can actually do. I can start being, on panels, I can go on podcasts and talk about my major, I can write a blog, I can write publications. There is a lot of power that I have. So if you have a master's or a bachelor's plus 5 years, you can move to step number 2. If you don't have an advanced degree, then you have to show exceptional ability, which is what I was just mentioning, right? Like showing that you have published, that you are a trusted expert in your field, that you go to panels. So once you establish either the advanced degree or the exceptional ability, either, it's not both, just either, then you can move ahead to the next step. The next step is showing that the work that you're doing is going to be for the national interest of the US. And I can go more in detail about that. The second thing that you have to show is that you as a professional are well established to advance that endeavor and do the work. Number 3 is that it is in the benefit of the US to waive the perm. And I'll give you a few examples if you want.
Sure. So as a manifest law firm, are you able to help somebody who says, my employer is not starting my green card process, or I'm currently a student, I want to set a path so that I will become eligible to take NIW route? Can your firm evaluate and give suggestion? Can we do NIW or not? Because it's a self-petition, which means anybody can approach. So is that something that manifest law is able to help?
Not only that, but we also have a program that mentors the students or the professionals and help them with a roadmap to start building their portfolio, so that when they're ready in, like, let's say 4 to 6 months or even a year to apply, they have established a very strong portfolio and credentials to be able to apply for this application. And I don't think I've heard of another firm that does that. We're very hands-on. A lot of the attorneys here are very passionate about the work that we do, especially helping foreign talent. Very creative. We've seen it all. Like I said, I have almost 10 years of experience. Other attorneys have more than that. So we are able to have to provide a consultation for foreign nationals that are interested in self-sponsoring. We review their materials. Many times they have a strong foundation, right? Like they have a good degree, like a degree in science, but they haven't really gotten a lot of attention for their work. So that's where we come in as well. Like we help them. Like here, you can reach out to these organizations, or like, why don't you apply for membership to this fellowship? Like this is going to help you with these requirements. So there is a lot of things that we can do.
Okay, fantastic. And to the listeners, if you have not watched the previous webinar I did with Attorney Nicole from Manifest Law, where she explained about O1 visa and also an NIW, as well as EB-1, and how they can also help with EB-1. So that's something for you to think about. And they also offer free consultation for you to schedule, and go check it out. Okay. All right. So next question. The job description that will be written to file for in-perm, are they writing it based on the current role the person is doing, or based on the future role the person will join once the green card is approved?
It's for the perm role. So if the person is basically doing the perm role now, then it will be the job description for now. But if the person will be stepping into this role later on, is the description of that role.
Okay. Next question from Pushkar. Can we have the ability to file perm with an employer B while working with an employer A? If my 6 years is going to max out, my perm with employer B is still in process, will I be able to work with an employer A? How is it possible?
So something that is important to keep in mind is that the perm role is basically for a future role, right? So you don't have to be working for an employer for them to be able to file the perm application. They're just putting forth the argument with the government, like, hey, we would like to offer this person this job and sponsor them for a green card.
Okay,
Like I said, you can even be abroad. You don't have to be in the US.
fantastic. All right. Let's see. My 6-year cap will complete on December 7th. My I-140 is filed in premium processing, still waiting for approval. What are my chances here? Very good question, Venkatesh.
So if you file with premium processing, you will, it depends on when you file, but you will get a response within 15 business days, sometime sooner. So as soon as you get the approval, you can file for the H-1B extension for 3 years. So it's important to have a good strategy, to be in open communication with your attorney, because you have to plan, right? Like it takes time to prepare an H-1B application extension. You have to file the LCA, which takes 7 to 10 days, right? So you have to have a good strategy in place for making everything happen.
Sure. So today is December 4th. This person basically has 3 more days. So if the status is expiring on 7th, would they have to leave the country and wait until I-140 is approved, then file for H-1B with approval while the person is abroad? Is that what they will end up doing?
So likely, yes. So if they have any time to recapture, that's why it's so important to take time out of the US, then the employer might be able to file for a new H-1B to bring this person back. But then you have to be mindful that then the $100,000 fee might apply because the approval might be sent for consular notification because you don't have status anymore. You don't live in the US anymore. So it
Ooh.
takes a lot of moving parts.
Wow. Okay. So very tough spot for them to be in. Can somebody apply EB-2 or EB-3 through PERM and in parallel do an NIW through self-petition?
Absolutely. People do it all the time. People do it all the time.
Okay.
It just most employers want to sponsor two processes. But if you're able to pay for it by yourself, totally.
Okay. What's the current processing time for PERM? Is there anything that has been done to speed up the process?
So unfortunately, the Department of Labor relies heavily on federal funding. It's not like USCIS. USCIS relies on filing fees. So what happened recently with the government in the US, that it was shut down, the whole portal for PERM, LCAs, everything that's done through the Department of Labor shut down and didn't process applications. So that caused a delay of a few weeks. I don't know from the top of my head if there is anything that's actively being done by the government to speed up PERM, but there is a backlog. There is a huge delay, which is why it's so important for people that get hired, as soon as they get hired, to start having these conversations with their employers, not to be afraid, and also to be able to articulate what the process looks like, because it could sound intimidating for an employer, but it doesn't have to be. It's actually pretty straightforward.
Okay, awesome. We did not talk about prevailing wage determination, which is a step within the PERM process. So I have a question based on that. So my PERM is yet to be filed. It's still under PWD process. I have less than 2 years left on my H-1B. We recently had a layoff in the company, and the new PERM filing process might be blocked. So could you explain what is PWD and what is the impact of layoff on the PERM process?
Sure. The PWD is the prevailing wage determination. So this is a step that you have to do in PERM, where you have to file a request with the Department of Labor for them to give you a prevailing wage. So you file an application and you tell them no, you let them know this person will work in New York City. And for the role in New York City, you will require at least a bachelor's degree or 5 years of experience in electronics. So then based on that information, the Department of Labor gives you a prevailing wage and tells you, based on the market, based on the credentials, this is how much you have to pay them at minimum. So the employer, when doing the recruitment process, takes that number and uses that number, at least that number or higher, to advertise all of the postings, right? There is a trick though. There is something that people can do, especially in this situation. You don't have to wait for the prevailing wage to be issued to open recruitment. You can do concurrent recruitment with concurrent prevailing wage. Some employers don't like to do this because what if the Department of Labor comes back with $150,000 and they did all of the recruitment with $100,000? All the recruitment, all the money they did goes to waste. So that's why employers like to do prevailing wage first. Once they have the prevailing wage number, then they use the number to advertise. But employers that are savvy and that value their talent and pay fair wages do both. They file the prevailing wage determination and they advertise the job for a number that's not too low because they know that it's going to come back with that number or lower. And you save like 6 months, 6 to 8 months.
Okay. And is EB2 process faster than EB3, or as of now, both looks around the same?
So in terms of faster, when you are doing the perm or the labor certification, it's identical, right? You have to go through the same process, advertise, get resumes, review them, file. Where I think there is a distinction in processing times is for the visa bulletin. But no one can predict which category is gonna retrogress or go forward. So people don't know that. I think where it helps is, for example, in terms of doing the labor certification. It's logical, right? If you're advertising for a job that requires a master's and 2 years of experience versus if you're advertising for a job that just requires a bachelor, which one do you think is going to get a lot more resumes?
Okay.
And then it's difficult to prove to the Department of Labor that this person can do the perm. And then going back to the layoff, I don't want to skip the layoff question because it's very important. Right before you file, you go through the recruitment process. Right before you file with the Department of Labor, you have to do something called the layoff analysis. Basically ask HR, hey, have you done a massive layoff within the last 6 months? Remember, we're talking about someone we want to sponsor in New York City, right? Masters in electronics. Have you done a layoff in the last 6 months in New York City for a job that sounds like the one that we are recruiting? If they tell you, yes, we actually fire 10 people with the same credentials, with the same job, then you have to put a pause, wait for 6 months to cool off, and then start that process again. Because how can you make the argument to the Department of Labor that there are no people available to work when you just fire people with the same credentials?
Okay. All right. I think another good question from an attendee. Let's say I'm maxing out all 6 years, even with recapture. My perm is pending less than 1 year. If I leave the country, will I be able to get that 1 year extension after the perm has been pending for more than 365 days? Will I get the 100K fee applied to in that case?
So I think it depends if the government allows for you to reactivate that H-1B or if it sends you to apply again for the cap. So it really depends, right? Let's say best case scenario, the government lets you reactivate that H-1B and they approve the H-1B, but you're abroad and you don't have a visa stamp, your visa stamp expired. You will likely be subject to the $100,000 fee. The government has provided more clarity on this fee, but it's really unclear. Attorneys haven't really received approval notices that are sending people to the consular notification and thus implementing the 100,000 fee. So we don't know how the government is playing this, right? Because the way that it reads on the proclamation by the president is that if you are outside of the country and you don't have a visa stamp, then you're subject to the $100,000 fee. So what does that mean? Legally, you have to meet both of them. So you have to be lacking both of them for the $100,000 fee to apply. If it said, you are abroad and they file a new H-1B and either you have or you don't have a visa stamp, then it applies. Then it will be different. But it says and. So you have to meet both requirements for the $100,000 fee to apply.
Okay, awesome. Let's look at another question. I'm on H1B. My priority date is June 2020 on EB-2. Can I move to EB-2 NIW, and can I have both?
So if you have a priority date under EB-2, it doesn't really, well, unless you want freedom from choosing the employer, it doesn't really make sense in terms of processing time because you will still be under the EB-2 category. But if you want freedom in terms of leaving the employer, then it is beneficial to apply for an NIW.
Okay.
And then you can request the priority date that you already have so that you don't have to start from scratch.
Okay. So I have another question about approximately what's the cost I'm looking at for an EB-2 NIW, the government fees, the attorney fees, and how much manifest is going to charge. I think, Tarun, you might have to schedule a consulting call with them directly so that they can specifically analyze your situation and then give you an option of how much it's going to cost. And the government fee is pretty common. Search for I-140 fee, you should be able to find it. Premium processing for a I-1 fee. I think that's the two fees for the government fees, right, Attorney Gabriela?
Right. So the filing fees are the government fees, and then the legal fees are for the attorneys.
Attorneys, okay. Can an employer file EB-2 NIW?
Yes, of course.
Okay, but why would you want an employer to file EB-2 NIW? And then if they can, is there a reason why you would see an employer will do an EB-2 NIW?
They want to keep the talent with them. And it's interesting that you mentioned that because we've had conversations with employers from the largest IT and banking industries, and they're very, very interested in paying for the fees and sponsoring NIWs for their employees because they realize that it takes a lot more money to go recruit this talent, train them, teach them the proprietary software of the company, and then to lose them because they don't have the ability to stay here permanently. It doesn't make sense. And as we know, and this is information that you can find online, there is such a lack of talent in the US for people in STEM, especially in AI. It's critical. It's critical.
So strategically, if the person is eligible for NIW, it makes them sense for them to do a self-sponsor, then pay whatever the cost that is required, then have the employer pay because you'll be stuck because that petition will belong to the employer. You cannot take it and move to another person, another employer.
So if the employer is sponsoring the NIW, then it's tied to the employer, right? But so, like I said, some people are going to the employers and being like, hey, like, will you pay for the fees? But I want to self-sponsor, and employers are saying yes, especially if you're prepared and you are able to, tell them the process, the fees, do your research, and tell them how much money they will be saving in the long term by keeping the talent that they have here in the company.
Hi, Martina. Do you have a question?
Yeah, actually, I was the one who asked this question about employers sponsoring the NIW. So between the employer filing for my NIW or the regular EB-2, which one would be faster?
The NIW will be faster.
Okay.
Because if you do perm, you have to do 2 additional years. You have to go through the labor certification. But part of filing for the NIW is that you make the argument to the government that it's in their interest to waive this because they need you right now in the US. Like, you don't have 2 years to wait.
Okay. And then we don't even have to consider about the prevailing wage, the PWD, because that's the main reason my employer is not willing to sponsor for my green card, because it came higher than what I'm being paid.
You can explain to them that they don't have to go through and do they understand that they don't have to pay you the prevailing wage until you get the green card, which could be in 10 years?
Yes, but apparently it came back way too higher than, and that's when they argued that it can be a liability, that even if it's like, as an Indian national, if it takes 10, 15 years for me to get the actual green card, still, what if they're not able to pay that?
Right, and they wouldn't keep you, right? So I think employers panic because this sounds complicated, but it's not complicated. When they make the assessment that they will pay you that, they're making the assessment that they will pay you that salary by the time that you jump in the green card, if they still have the job, if they still want to keep you. They're not saying we will pay Martina $300,000 regardless if she works with us or not. They're not saying that. They can just let you go if they're not able to afford you.
Right. And I mean, and it's been a year that my PWD came back. So by now, I think that has even expired, I guess, and they will have to refile it, right?
Yes, and an approach that employers take, and this is why you need to be with a really good attorney, is that they create a strategy, right? They refile the prevailing wage, but they're able to restructure that job description. Sometimes employers don't understand, or the attorney doesn't explain it in simple ways, that this job description is different. It has to be tailored for purposes. It doesn't really have to be the one that they would use to hire you per se, right?
Yep.
So, for example, they love to use manage and oversee other employees and have high level of this and high level of that, when in reality, you're not really doing a manager role. But that, when you file that description with the Department of Labor, it triggers manager, oversight of people, high level, all of that triggers a higher prevailing wage.
Right.
Okay.
And I explained them that as well, that first of all, it's been a year, it's expired. Now, we always can refile it. And when we do the refiling, let's file it in a way that it's not exaggerated to come back with a higher wage like that.
Exactly. Simplified.
Yeah.
Thank you, Martina. We have to move on. Appreciate your time.
Thank
you. So how are you doing with time, Gabriela? We are up about an hour. How long more can we go, and how many questions can I ask?
We can stay a little longer if you have the time.
Sure. Okay. So awesome. Another interesting question. Can my wife, who is on H4 EAD, apply for EB-2 NIW?
Of course, she can apply for her own NIW if she's able to articulate that she has an advanced degree or she meets the other criteria that we spoke about.
Okay. And Gautam, who is asking this question, you may want to schedule a call with Manifest Law Firm, and they have a free consulting option where they can evaluate your spouse's eligibility for EB-2 NIW or anybody else who have this option. The reason I ask this question is there is going to be several spouses who are on H4 EAD are dependent on the primary's EB-2 or EB-3. If the spouse has the ability for an NIW, probably it's good to have another option. So awesome. Let's bring in. Hi, Kiran. What's your question? Hey, Kiran.
Hey, Raghu. How are you?
I'm good. How are you? What's your question?
Hi, Gabriel. Really, this is my first session attending. It's really helpful. Thank you so much. Really helpful. Just a quick question. I got laid off last week. For some restructuring reasons. My perm was applied in December 2024. It's been exactly 365 days now. My perm is still pending. I haven't got approval since I got laid off. Is that perm still valid, or is it like, can I use that perm and labor application to apply for 1 more year extension? My H1B is expiring in next 6 months. So what are my options now? And how long this you do?
Thing got cut off. Yeah.
Yes. So in terms of unfortunately, the only way that you can port a perm petition or a labor certification is when you have already filed the I-140 and it's been filed for at least 6 months, right? Since you don't work for that employer anymore, you will need to have your new employer sponsor you, or you have the option of doing an NIW by yourself, so that you don't have to rely on another employer.
Tough scenario. Basically, you're going to deal with some difficult decisions, Kiran. That's what it looks like.
Yeah, it looks like it's a really bad situation now. Let's say if I go with your team, if your team can help me here with NIW, like a premium processing, how long will it take to get the decision back from the government?
So if you file an NIW with premium processing, I believe it's, let me just look it up because the applications have different processing times, but I believe it's either, just see, and this is something that you can look online too. NIW I-140 premium processing time, 45 business days. So it takes 45 business days to get an approval or a request for evidence. But likely, if you qualify, an approval within 45 days.
Okay, awesome. One last question, sorry, Raghu. Let's say, I've got one more option, going to college back in F1 visa, like starting like a day one CPT. Can an employer apply for my perm on day one CPT?
Can your employer apply for, can you repeat the question?
Can the employer apply for perm while he is doing an F1 visa on day one CPT?
If he has the credentials for the job that's going to be advertised for the perm, yes, of course.
Thank you so much.
All right, thank you, Kiran. All right, so let me look at a few more questions. We have a bunch of them pending. I'm trying to find something that we have not covered so far. My labor market test failed due to availability of qualified US workers. My FNIV is December 2026. What can I do? What is my best option?
So right now it's a little bit tougher because you tested the market and it showed that there are US workers that are qualified and willing to take your job. So your employer has to wait at least 6 months from the time they were able to find the US workers for everything to cool down and then start the recruitment process again. Or you can start working on building your portfolio and apply for an NIW.
Okay. Could you talk a little bit more about the recruitment process? One thing that we will hear is during PWD or recruitment process is going on, you don't get to hear anything from the attorney. It's pin drop silence.
Yeah.
There's no communication. So why is that? And what's happening when the recruitment is happening?
Yes, I'm so happy you asked that question. The thing that people don't understand is that the regulations for the perm process are very strict, and the Department of Labor doesn't want the foreign national involved or in the loop because they don't want to taint the process, right? Like they don't want the foreign national reviewing the resumes from the people that apply because it's in their benefit to not find anyone, right? Because they want to keep the job. So the way that we do it at Manifest, to balance both things, obviously to stay compliant with US federal regulations, but also to keep the foreign national in the loop, is that we provide general updates like, for your information, the prevailing wage has been filed today, or we just got the prevailing wage back, to keep them in the loop. But also we host town halls for companies that hire us to do the perm process for their employees. We host a town hall for the managers to understand the process, because that was one of the biggest complaints for other companies, right? That the managers are like, I'm a manager, I don't have training in this, like, and now you expect me to follow these regulations. So providing a town hall for the managers to keep them informed and to make them understand the process, and also a town hall for the foreign nationals so that they're able to ask questions. They know what's going on right now with the Department of Labor, what are the different red flags that we're seeing. But that is the reason why the attorney keeps the foreign national out of the loop, because the federal regulations ask for no employee involvement.
So the recruitment is done by the manager who posted the job, who are doing the interview process. They are giving the feedback to the attorney, say in a format that you're looking for. While this is happening, the foreign national cannot have any communications about this process either with you, or is the understanding correct?
I wouldn't say any communication. I would just say they really kind of have a say in, for example, who qualifies or not for the job, right? Like they can ask Yeah, they can do that. But there are ways to keep the employee in the loop and understanding of what's going on. But the attorney is the one that guides the manager to do the recruitment. So for
Okay.
example, we send the manager instructions. This is what you need to do, this is how you need to do it, and send us an affidavit to say that you posted this in a location for 10 business days, and then we keep all the evidence. So we guide the manager through the process.
Okay. All right. Who makes the determination that we found US workers, or there is also a concept where perm will send a query and the perm certification takes longer time. So what does that mean?
Who makes the determination of who qualifies?
Yeah, so two questions. One is during recruitment process, if there are qualified US employers, what happens then? And second question, perm application is submitted, and there is also another criteria where your application has been selected for perm query. Extra validation, it takes longer time. So what are those two things?
So for the first one, who makes the selection of whether who qualifies or not is the manager. So the manager, because the manager is the one that's basically the employer and the one that's familiar with the job that's being advertised.
Yeah.
This is why it's critical to have a good attorney, because a good attorney will be able to explain to the manager the process, the target, what we're trying to do here, because sometimes managers get confused and they get very fixated with the job posting, right? Or for example, they're like, oh, but this US worker qualifies for 3 out of the 5. I would like, no. He has to qualify for all of them. He has to meet all of the requirements, not just 1 or 2. And it has to be at minimum. So that's why it's good to guide it. Just give me 1 second. I'm going to charge my computer because it's
Sure.
it's charge.
There's a lot of questions. I'm just trying to pick questions that is short for me to read. Anything that has been typed for like 4 or 5 sentences, very hard for me to read. So I will pick another 3 or 4 questions and then we'll wrap up today's meeting. Are you good, Gabriela?
Good.
Sure. So for the second question, what is that query that comes from Department of Labor? It's like recruitment that labor will oversee it, or what does that query means?
Like an RFI, like
Perm has been filed
okay.
and not approved, but you got questions about the recruitment process.
Right. So it's an RFI.
RFI, okay.
RFI. I'm sorry, RFI. So it happens. It's common for the Department of Labor to come back and say, hey, we want more information on this recruitment period. That's why it's when you file the labor certification, you don't have to include evidence. You just fill out a form. You have to keep all the evidence on the side because you don't know what perm is going to get audited. You don't know what case the government is going to come back and say, hey, we want to see proof that you posted the ad on 2 Sunday newspapers of general circulation. So that's why a good attorney keeps track of everything, right? Like we post the ad, we make a copy of the newspaper, we post the tear sheets from the press, everything together, everything organized. So when they come back, it's pretty easy to just provide copies and it gets resolved pretty easy.
Okay, all right. Is green card process through cap exempt H-1B different from a green card process through a cap-based employer?
Can you repeat that question?
There is a cap exempt H-1B. Somebody's working for.
Oh, the cap exempt, yes.
Yeah, so is the green card process different in both the categories?
No, it's the same.
Okay.
The only difference is the cap exempt, you don't have to be placed on the lottery and you can start working anytime. You don't have to wait for October 1st.
Okay. So during the recruitment, if the manager says to you, we found a lot of qualified US workers, what happens next in the green card process for that applicant?
You can file the perm. You have to pause and let market cool off for 6 months and then restart the process again.
Okay. Tarun, we have the recordings of the previous ones. Just give me 1 second. I will get that to you. I'll post it on the chat for anybody who's interested to watch the previous replays. I think we did. I'm just looking at view my channel. I am posting it on the chat, folks, so you can get access to the previous recordings. There you go. I posted on the chat. You should be able to watch on the YouTube channel.
And just to briefly mention, people can also apply for the EB-1, if they're able to show that they have extraordinary ability, which is just meeting 3 out of the 10 requirements.
Mhm.
You can do this by showing that your compensation package is higher than people in your field, that you're being quoted. A lot of people in STEM have Google Scholar profiles. You can show who's citing you, that you're invited to be on panels, that you're a speaker, that provide recommendation letters. So there is a lot that people can do to build that profile if they don't want to rely on the unpredictability of the perm or the waiting time.
Okay. Hi, Venkat. I believe you are the one who asked the questions about I'm running out of time on December 7th. Do you have a follow-up question you want to ask?
I think he's muted.
Yeah, it's muted. Hopefully you're able to, I'll leave you on for a few minutes while I'm going through the next set of questions. I have a startup company. Can I file my perm and I-140 if I'm running my own company?
It depends on how your company was established. So if your company was established as a sole proprietorship,
Mhm.
it gets complicated because there is no distinction between the employer and you. But if the company was established as an LLC or as something else like that, there will be the possibility for your company to sponsor you as an employee.
Okay. Another good question, I think that was not asked before. Let's say I have the skills to prove to USCIS, but it's confidential. I'm not able to share with. How am I able to get EB-1 or EB-2 NIW?
We actually get this situation a lot, especially for people. I mean, you're working for the national interests of the US, right? Like we have people who are working in the military, in the Department of Defense, developing things that are of high national security. I think there are ways to do it. We've done it. It's just how you structure, how you package the material. If you're able to show public available data showing the impact that similar technologies that you're doing or technologies that you're doing have, the letters of recommendation of people talking about the impact of your work, even if you don't provide specific samples of your work. So there's definitely ways to do it.
Okay. Hi, Dinesh, you are up next. What's your question?
Hey Raghu, hey Gabriela, thanks for the opportunity. So my question is, I am currently nearing the end of my fifth year of H1B, and my perm 9089 was filed back in June. So what would be the case if I decide to switch teams or move to a different state right now? Would I need to redo my perm from the scratch from prevailing wages, or do I get to keep the priority date?
So you haven't filed the I-140, right? Just the perm.
Yeah, just the perm.
So unfortunately, perm is tied to it's tied to a location. So if you
Okay.
move before you have the I-140, you will have to restart the process and file a new perm, and you lose the priority date.
Okay.
So even though this job is for a future employment, is there a way an employer can say, when this person used to be here, but after the green card is approved, this person will be employed in this place, but in between we are moving?
So there is a tip that I want to give people, especially the ones that are about to file their perm. When you file your perm, especially if you have an understanding that you might move within the company, like if it's a large company, make sure that the location that's listed on the entire perm is the headquarter and then all other locations. That's called a mobile perm, which means that you can move anywhere you want because it covers the whole country. Now, I don't know the location that he included in the perm that was filed, and I don't know if this was for a future role or if this was for the role that he's currently on. So that would play a different role.
Okay, very good strategy, right? Things like this, unless you talk to an attorney who knows what they're doing, and if they had filed without taking this into account, probably he is stuck to restart the process. If in case attorney was thinking ahead strategically, then probably they would have filed it in that way. Dinesh, thanks for your question, Dinesh. Any other question?
No, that should be good for now. Thank you so much, Gabriela.
All right, thank you. Okay, I think we will wrap up after one more question, Gabriela. Okay, there is we will never stop if we keep going.
We can always have another one too.
Yeah, of course. Yep, we will do that. I didn't expect this will be such a popular session, so we can probably do another follow-up to
No,
this.
Raghu, the thing is that not a lot of attorneys are able to explain the perm process in a simple way, or have the experience of doing perm. It's a very coveted skill because they don't want to do it. I've done this for 10 years, so I can talk about perm in my sleep.
I'm trying to see if there's any unique question. I'm just going to pick one person and then we'll wrap up after this.
Hey, hi, Raghu.
Hey, what's your question, Pushakar?
My employer is not going to file my perm and I-140, but my cousin has a company. So he's willing to file for me for the future employment, but he don't have any like a manager or HR in his company. It's like a startup company. So can they file for my perm and I-140?
If they have the need for a role that you can do, yes, of course, they can file for the perm and eventually for the I-140 to sponsor you.
Okay, so from the as a employer perspective, they should not be like. Is there any requirement they should fulfill? Like they should be having minimum employers working for the company, or they should be having some kind of income or anything like that.
No, we file perm for startups that had like 3 employees.
Okay. Okay. Thank you.
Okay, thank you, Pushkar. All right, so attendees, if you're still hanging out with us, I posted the link in the chat to specifically request this free consultation, and they'll be able to track that you came through Happy Schools. So that link is on the chat. I'm reposting it again. This is the page that you will run into. From here, you can request the consultation. And we will definitely try to have another follow-up session on the green card process because there is a lot of questions that is still pending. We couldn't get to it today. But for those, if you are trying to explore, if I will become eligible for EB-2 NIW, can I self-petition it? Or can I become eligible for O1 or EB-1 category options, A, B, or C? How do I become eligible for O1 or NIW? I'm just on F1 student. I want to build up my profile to NIW. Instead of being reactive, when your time is running out, you're trying to figure out what can I do. If you have time, if you're just an OPT or master student, have a consulting call with Manifest Law. You get a free consulting call. They can help you guide, create a plan. Only if you think you want to take up, go for it. There is no obligation for you to hire them. It's just an evaluation for a strategy. You probably might talk to Gabriela, you might probably talk to Nicole or another attorney on their team. So give it a try, and we will definitely see you on another webinar. Gabriela, thanks a lot for spending close to 1 hour and 20 minutes explaining the green card process with us.
Thank you for having me. I had a lot of fun.
All right, thank you. We'll catch up another event. Take care, everyone. Bye-bye.
Good night.
Thank you, everyone. I'm just going to hang out for another quick second because the streaming is always delayed. If I cut this off, then it kind of ends in the Facebook and YouTube, it ends abruptly. So I'm just going to hang out for another 10-15 seconds to make sure the stream end is there on the platforms. Okay. All right, that's good. End live video, and thank you, everyone. Bye-bye.